Hello everyone and welcome to the Victorian Civil and Administrative Tribunals event, Becoming a Guardian or Administrator. Over the next hour, we'll be going through the roles and responsibilities of becoming a Guardian or Administrator. My name is Zoe and I'm the Deputy Registrar for the Human Rights Division at VCAT, which oversees guardianship and administrative matters. With me is Brendan Hoisted, a senior member here at VCAT, who's overseen guardian and administrator cases for the last 7 years.
Well, good afternoon, and thanks for this opportunity in Law Week 2021 to speak about the role of the guardianship list of VCAT. Our aim today is to assist and inform people who may be considering an application or who may have a matter already before the guardianship list. The law that guides VCAT in deciding applications for guardianship or administration is the Guardianship and Administration Act 2019. That act replaced an earlier version of the same legislation, and the new act came into effect in March of 2020. The new act has a strong emphasis on what's important to the person with the disability. The legislation speaks about the person's will and preferences, and in fact says that the person's will and preferences should direct, as far as practicable, decisions made for the person. We appreciate that for some people, their disability causes a lack of decision-making capacity. In such cases, we need to look and see whether, because of the disability, the person has a need for a substitute decision maker. Sometimes an order might be needed to protect the person or their estate, and sometimes an order is seen as a means of fulfilling the person's will and preferences. Today, we'll be talking about what VCAT needs to be satisfied about in order to appoint a guardian or administrator. We'll be talking about the responsibilities of a guardian or administrator. And we'll also spend some time talking about enduring powers of attorney and how medical treatment decisions can be made for a person with a disability. Applications for the appointment of a guardian or administrator are decided by members sitting in the guardianship list of VCAT. Guardianship is about having the authority to make lifestyle decisions. Decisions like where a person is to live or what services they might receive to support them. It might also be about medical treatment or who gets to spend time with the person. Administration is the responsibility of looking after a person's finances. Or perhaps it might also be about the person's legal affairs. An enduring power of attorney is a document signed by a person who has decision-making capacity, in which the person states who they want to make decisions for them if at some point in the future they lose the ability to make decisions for themselves. In the document, the principal, that's the person who signs the power of attorney, also states when the power is to commence. For example, it might say that the power commences when I lose the ability to make decisions for myself. The principal usually also states what power is being given. For example, to make decisions about personal matters or to make decisions about financial matters or both. Sometimes there are disputes about whether the principal had capacity to make the appointment when they did, or there might be concerns about decisions being made by the attorney. That's the person who is appointed. Applications for guardianship or administration, or about enduring powers of attorney, are decided at a hearing. The VCAT member conducts the hearing. By that I mean the member hears what everyone has to say, especially the person the hearing is about. The member will know the law and apply it to the facts and circumstances of the matter. Everyone will get an opportunity to say what they think before the member makes their decision. Usually, at the end of the hearing, the member makes a decision and explains it to the people who are at the hearing. During COVID, we've been conducting hearings by telephone or video, but soon we'll be recommencing hearings face to face. And Zoe will tell you a bit more about that. So, the first thing that the member needs to be satisfied about is that the person has a disability. And we know that there are different types of disability. Some are present from birth, some are lifelong, others might result from an accident, a medical event, or a condition like a mental illness. Other disabilities might emerge later in life, like dementia. In order for VCAT to make an order of guardianship or administration, VCAT needs to be satisfied not just of the disability, but that the disability causes a lack of decision-making capacity. If a person has a disability, they still might be able to make some or many decisions for themselves. Capacity means being able to understand the matters that are relevant to a decision, to remember that information, to be able to use or weigh the information, and to communicate the decision. Communication doesn't have to be by spoken word, it can be by gesture or other means. The person who's making the application to VCAT needs to provide us with a report from a treating doctor. That report needs to inform us about the assessments that have been done and the opinion about whether the person has a disability and whether it affects their decision-making capacity. The report needs to be fairly current because decision-making capacity can change over time. Now, not every person with a disability will need to have a guardian or administrator. Where decisions are able to be made informally, then you may not need a guardian or administrator. For example, a parent or a family member can assist their family member with an application for the NDIS and can participate in the planning meeting. They can do that without being the person's guardian. Similarly, you can assist a person with an application to Centrelink or to set up a bank account without being their administrator. As a family member, you can help with medical treatment decisions without being a guardian. Sometimes it's because there's a disagreement or conflict within the family that will indicate that there is a need for a guardian or administrator. By that I mean, where different people have different ideas about what is best for the person, or because they believe the person wants different things, it may become necessary for there to be someone with authority to make a final decision. In deciding whether to appoint a guardian or administrator, it's necessary that the person with the disability attend or participate in the hearing. This helps the member understand the issues of disability and capacity, and importantly, the question of need. Attending the hearing enables the person themselves to tell us about what's important to them and whether they want or feel they need help in particular areas of their life. It also gives them, importantly, the opportunity to tell us who they want to have assist them. We understand that sometimes a person may not want help, but others feel that help is necessary. This question is the question of whether there's a need, and that needs to be explored and decided at a hearing. Now, if a person can't attend a hearing in person, we'll be able to talk to them by telephone or by video conference. It's important that the person with the disability knows about the application and has an opportunity to participate in the hearing. Of course, if the person doesn't want to attend, then we won't force the person to attend. Where it's decided that a person needs to have a guardian or administrator, we then need to decide who to appoint. And as I mentioned, the wishes of the person will be important to making a decision about that matter. The nominated person has to be willing and suitable, has to be willing to do what the Act says they must do. Importantly, they must be in a position where their interests aren't in conflict with those of the person about whom the application is made. The Act, the Guardianship and Administration Act, emphasises the importance of families and friends who have a continuing relationship with the person. An order of guardianship or administration will specify who is appointed, what authority they have, and when the order will be reassessed. Guardianship orders are usually limited to those matters where there are decisions that are currently needed. For example, where the person will live, or what services they need. Guardianship orders are usually made just for 1 year, and administration orders are made for 3. At the end of the order, or before it, we have a hearing to decide whether the orders need to continue. They might need to be varied. Sometimes they can be revoked. Administrators have to provide accounts to VCAT each year. And in those accounts, they're required to show us how they've managed the person's financial affairs. Where it's not possible to gain an understanding of the person's will and preferences, then the Act says that we must make decisions that will promote the person's personal and social well-being. We have to recognise the person is an individual. We consider their values, their culture. Where the person has lost their decision-making capacity later in life, we have to consider the decisions that the person made for themselves when they were able. And that can often help us understand what's important to them. A guardian appointed by VCAT has a strong obligation to consult the person about the things that are important to them before making a decision. The Act says that a guardian or an administrator can't override the person's will and preferences unless the decision the person wants would result in serious harm. Sometimes a person with a disability might not appreciate the assistance that they need. If the person says that they want to live alone, you have to consider whether that's possible. For example, I guess you consider whether supports could be provided to make it possible. If you determine that living alone, even with services, if the services were not sufficient to meet the needs of the person, if you decide that that would result in serious harm to the person, then you can make a different decision. Guardians and administrators can seek the advice of VCAT, and they do that sometimes when there are difficult or contentious decisions to be made. For example, if as administrator you feel it's necessary to sell the person's home to pay for their care, but the person themselves doesn't want the property to be sold, you could apply for the advice of VCAT, and VCAT can approve what you propose or give you advice. VCAT can disapprove what you propose also. Where the administrator acts on the advice of VCAT, that protects the administrator. Sometimes a person with a disability needs some assistance, but is still able to make their own decisions. And a feature of the new Act is that VCAT can now appoint a supportive guardian or supportive administrator. To make such an appointment, VCAT has to be satisfied that the person is still able to make their own decisions, but that they need a bit of assistance. That assistance might be in accessing information to consider in order to make a decision. The supportive guardian can access the information on behalf of the person. The supportive guardian might communicate to other people information about the person's decision. Or a supportive guardian or an administrator might assist the person giving effect to the decision made by the person with the disability. Enduring powers of attorney are relevant to people who are competent, but who are concerned to put in place some arrangement for the future in case they lose their ability to make decisions at some later point in time. VCAT doesn't make an enduring power of attorney. It's a personal appointment. To make an enduring power of attorney, the principal, that's the person who gives the power, has to understand what power they're giving, has to remember the information, to use or weigh the information in deciding whether to give a power, what power, who to appoint, when the power should begin. They might want to also give some instruction to the attorney that they're appointing about what they want or don't want. An enduring power of attorney means that the power continues even if the principal loses decision-making capacity. A competent adult can appoint an attorney to make personal decisions, financial decisions, or medical decisions. It's really important that the person who's considering making an enduring power of attorney think really carefully about who they're going to appoint, because they give that person considerable responsibility and authority. It's really important to choose the right person for the job. The law in Victoria that relates to medical treatment decisions is covered in the Medical Treatment Planning and Decisions Act, and that came into effect in 2016. The Act does a number of things. It gives the person, a competent person, the ability to appoint a decision maker or a support person, like an enduring power of attorney. A person can also make an advance care directive or a values directive. An advance care directive is where you commit to writing a statement about medical treatment, in particular, medical treatment that you choose not to have at some stage in the future. An advance care directive is binding on your doctors, and it's binding on any decision maker that you might appoint or that might exist. A values directive is something less than an advance care directive. It talks about the things that are important to you, but doesn't prescribe particular treatment that you want or don't want. It leaves the decision to the decision maker to consider alongside the statement about what's important to you. Medical treatment decision makers, whether appointed or by virtue of being a family member, have to give strong attention to your preferences and values. I mentioned earlier that family members can assist a person with a disability to make decisions about medical treatment, even if they're not guardian. The Medical Treatment Act says that there's a list of family members who can make decisions for a family member with a disability if that person can't make their own medical treatment decisions. Of course, a family member who hasn't been appointed can't make medical treatment decisions if there is a guardian appointed by VCAT with authority to make medical treatment decisions, or a medical treatment decision maker appointed by the person themselves when they were competent. But if a person hasn't made such an appointment and doesn't have a guardian for medical treatment, but needs decisions about medical treatment, then the Medical Treatment Planning and Decisions Act sets out a list. And the list is the spouse of the person, if they have one, a primary carer. By that, I don't mean a professional carer, but a personal carer, personal as in family, an adult child of the person, a parent of the person, or an adult sibling. So if there's no appointment by the person, there's no guardian, then you look at that list in order. And that person has authority to make medical treatment decisions on behalf of the person who, because of a disability, can't make their own decisions. I'm going to hand back to Zoe now to talk a bit more about the process for making applications to VCAT. Thanks, Zoe.
Thank you, Brendan. Now I would like to go through where to find further information around guardianship and administration, how to lodge an application with the guardianship list, and some hints and tips for when you do apply. There is some really helpful information on the VCAT website about the duties of a guardian or administrator, how we make our decisions, how to prepare for your case, and what to expect on the day of your hearing. The link to the website is displayed for reference and is a good first step for people who are wanting to submit an application to VCAT and are wanting to know what we do and what we can and can't help with. If after your research, you need to lodge an application for a guardian, administrator, or supportive guardian or administrator, you can navigate to the Guardianship Hub portal through the VCAT website and create an account. I'll play a video for you now, so hopefully it comes up on my screen. 1 second. So from the VCAT website, you select case types, and under the Guardian and Administrator tab, on this page, it shows how you, what you need to do to apply. You select the application you would like to lodge, and you select the How to Apply button. Here it shows the application checklist of what you need to do before you apply, and then you select How to Apply, and it goes to the Guardianship Hub portal. After you have logged in, you just fill the application questions as accurately and as detailed as you can. You can also save your application and come back to it later to complete it. The Guardianship Hub allows you to see the applications you have lodged, access your submitted application, and upload any supportive documents. You will also receive your hearing notice and any orders through your Guardianship Hub account, and helpful reminders with details of your upcoming hearing. You can also lodge an application to us via email, attaching a PDF version of the form, or you can send your completed application through to us via post. Important information to provide with your application is any evidence of any enduring powers of attorney document that has been made, and medical evidence that outlines the proposed represented person's disability and their decision-making capacity. The medical evidence will need to be recent within the last 3 months. There is a medical report template on the VCAT website, which can be used by applicants to give to the treating doctor of the proposed represented person, which outlines the information VCAT requires to make our decision. If you are having trouble getting the treating doctor to complete the medical report template, you can write into us and advise us of the issues you're having for us to consider. If no medical evidence or details of the person's decision-making capacity is provided to us, this could result in your matter being postponed to a future date until the evidence can be provided. It is also really important to provide as much detail as you can with your application and ensure the information that you do provide is accurate. Spelling errors in the proposed represented person's name or any other party's name can result in errors to the final order. This will need to be corrected before you can use this order, which can cause delays in decisions that need to be made for the represented person. This is also the case with names that have been shortened and do not match with the identification documents of the person. If information is missing, if handwriting is really hard to read or details are incorrect, this can result in delays in processing your application, as we will need to follow up these details with you. After you've lodged your application, you are required to send a copy of your application and any documents that support your case to every person mentioned in the application. As the applicant, you should do as much as you can to make sure the person you're applying about is aware of the application and of the changes that might happen in their lives if an order is made. Once the application has been submitted to us, we then assess the application for risk and urgency. In the Guardianship and Administration Act 2019, all new applications are to be scheduled within 30 days of lodging the application. If there is imminent risk, an immediate decision about a person's accommodation or financial affairs needs to be made, or you believe your application needs to be expedited, detail this in your application form or write into us providing the reasons your case needs to be prioritised for us to consider. As Brendan had mentioned earlier, we strongly encourage the person you are applying about to come to their VCAT hearing, as the decisions we make affect them. We try to make it as easy as possible for them to come, so if it is not possible for them to attend a face-to-face hearing at VCAT, we can organise for them to attend via phone or via video conference if that is easier for them. We can also organise language or Auslan interpreters for anyone attending the hearing, hearing rooms with hearing loops if someone is hard of hearing, and we can do bedside hearings in some circumstances. If you would like any special hearing requirements organised or have a preference in attending the hearing either face-to-face, via phone or via video conference, please do add this information to your application or send us an email with your request. This will assist us when scheduling your case for hearing. Next up, Brendan is going to answer some questions that have been received from the audience over the preceding couple of weeks, and he will answer some general frequently asked questions we often receive at VCAT. We're going to devote the rest of the presentation to going through those, plus he will go through a typical case we receive within the guardianship list. So Brendan, the first question, what if a person with a disability has some decision-making capacity, but just needs some help with certain decisions?
Thanks, Zoe. If a person has some decision-making capacity, then it's important that anyone assisting them try and give effect to the person's will and preferences. The person may, with your assistance, be able to make a decision, and if there's no dispute about the decision that's been made, then no formal authority might be needed. But in some matters, there might be a need for someone to have some authority. And where a person's got some decision-making capacity, then a supportive guardian or supportive administrator might be able to provide the level and type of assistance that the person needs in order to make the decision for themselves. And we would think that that would be a pretty good outcome, because we're not taking away the person's right to make their own decisions if they can. We're just putting in place a mechanism to provide them with the type and level of assistance that they might require for particular decisions. I guess it would also be worth exploring with the person, perhaps with their doctor, whether the person has the ability and wish to appoint someone like an enduring power of attorney, a more formal appointment, and that appointment could take effect at some future date or point in time. Back to you, Zoe.
Thank you, Brendan. Question number 2 is, what if a represented person under a VCAT order regains decision-making capacity?
Yeah, well, where that happens, and it can happen, if a person has a mental illness, it's not uncommon for the condition to affect them at some times and then not at other times. And when we make a VCAT order, the order will state that the order can be reassessed at any time in the future. So if a person regains decision-making capacity, then we want that person, or if you're assisting that person, we want you to make an application to VCAT to reassess the order. It's helpful when you're doing that if you can also source a report from the person's doctor, someone who knows the person, but someone who can confirm the view that the person has regained their decision-making capacity. On reassessment of an order, we can revoke or cancel the order. We could vary it. We could change it from a guardianship or administration order to a supportive appointment. It would be decided on a case-by-case basis, but importantly, I would encourage the applicant to bring the matter back to VCAT.
Thank you. Question 3 is, as an administrator, what are my reporting requirements to VCAT?
This is a really important question. When VCAT appoints an administrator, they have the ability to manage the financial affairs of the represented person. They may also be given authority to make decisions about legal matters. They may also be given authority to make big decisions like selling property. Every administrator appointed is required by the order to firstly submit a financial statement and plan. We send that form out to the administrator soon after they're appointed, and they have to fill it out and send it back to us within 6 weeks. Now, the financial statement and plan, or FSP, is a snapshot of the represented person's financial affairs at the time of the appointment. So it will explain what their income is and from what source or sources. There may be multiple sources. It will show us what the person's expenses are. They might be accommodation expenses, whether you're living at home or in care. They'll include money for personal allowances and money for future needs. The FSP also requires the administrator to tell us what the person's assets are. Do they own property? Do they own shares? What's the approximate value of the property or the shares? We want to know what the plans are of the administrator in relation to the property. We also need to understand if the represented person has any liabilities. Do they have a credit card debt? Is there a mortgage on the property? Do they owe someone money? So that snapshot is considered by one of our members. We need to understand it and approve it. And so the member looks at it, and if satisfied by the FSP, makes an order approving it, both as a statement and as a plan. Once a year, administrators are required to submit what we call accounts by administrators, or ABAs. And that's a report about the previous year. In a sense, it's a bit like a tax return. It reports on the previous year. So it tells us what the person's income was, what their expenses were. And we're looking, of course, to see that the person's income is higher than their expenses. It tells us how the person's assets now present. So we need to see, again, that the person's assets are growing, or if they've diminished, we need to see how and why. Perhaps money's been put into a refundable accommodation deposit for the person, or an annuity. The ABAs are examined on behalf of VCAT. And if we have any questions about what the administrator has done, then we will write to the administrator in the first instance and say, please explain this, or please provide us with this information. If we're satisfied by that, we write back to the administrator and say, thanks very much. We'll do the same thing next year. If we're not satisfied by the administrator's explanation, then we'll set the matter down for hearing so that we can have a further discussion with the administrator. At the end of that, we'll either be satisfied and continue the order, or if we're not satisfied, we'll look at changing the administrator.
Thank you. Question 4. Does an administrator need to keep every receipt for purchases made with the represented person's money?
I think the short answer to that is no, but I wouldn't want anyone to get the impression that you don't need to be careful and diligent in the work that you do as an administrator. You're looking after someone else's money. As an administrator, you'll generally work out a budget so that you make sure that you've got money identified for current and future needs. And part of the budget will include, generally, an allowance for the person for small items, things that they can choose for themselves. And we don't require the administrator necessarily to keep receipts for those matters, so long as they're within the budget and they're within the allowance made within the budget. I often advise administrators to keep, at a minimum, an exercise book in which they note bills that they've paid, monies that they might advance to the person for personal spending, just the things that they do as administrator, they can jot down there. And as well as having a good system in place, when it comes to doing the annual ABA, you find all the information you need is in that book. Of course, if you want to do that in an electronic form, it's probably a whole lot easier. But at a minimum, find a way to keep records and receipts for most things.
Thank you. Question 5 is also about administration. So as an administrator, at times it can be tricky figuring out what decisions I can and can't make, like giving gifts to family and going on a holiday with the represented person. What is some guidance you can give administrators wanting to seek advice from VCAT?
Yeah. Firstly, I would say that as administrator in relation to gifts, you should do what the person you're representing would do, if it's possible to know that. So for example, if you're administrator for your parent, you'll have the advantage of knowing what your parent decided when they were able to. And you should do that, providing it's affordable. Other guidance I would give is to say that gifts should be of a seasonal nature. So gifts for birthdays to other people who are close to the represented person are okay, providing they're modest in terms of their cost. As a general rule, we would say that a represented person shouldn't be gifting more than $100, or an administrator shouldn't be doing that on behalf of a represented person. If anything more than that is proposed, then before you do it, you should write to VCAT and explain what you think is appropriate and why you think it's appropriate, why you're proposing this. It might be a special occasion like a person's marriage or a big event in their life. When you're making a request to VCAT for approval to do that, you should provide us with a reasonable amount of information so we know what it is you're proposing, why you're proposing it, the value of it, whether there's an impact on the person's financial affairs or not. If it's reasonable on the papers, then VCAT might approve it on the papers. If it's a more complex matter, then VCAT will likely list the matter for a hearing with the administrator so that there can be a conversation about it. And at the end of that hearing, VCAT will make a decision approving it or not, or approving something as an alternative. I would say act cautiously. If in doubt, email us. Send a letter saying, this is what I think is reasonable, but I want to be sure. And that request will be put before a member and a decision made.
Thank you. Question 6. What if there are 2 people that are willing and able to be appointed as someone's administrator or guardian?
So VCAT can appoint more than one person to the role of guardian or an administrator. Sometimes we appoint 2 people. Rarely we might appoint 3. Where VCAT's appointing more than one person, we have to decide how they will exercise that authority. We say in relation to guardianship, lifestyle decisions, that appointments are joint decisions. In relation to financial matters, VCAT can appoint people to act jointly or can appoint people to act jointly and severally. Jointly and severally means that they can act together but can act separately. So, for example, that would mean that they don't necessarily have to both go to the bank together. The order under which you're appointed will state whether the appointment is joint or joint and several.
Thank you. Question 7. What if joint administrators have conflicting views on a decision to be made for the represented person?
So if joint administrators or joint guardians can't reach an agreement about the matter, then they're duty bound really to bring the matter back to VCAT. If they're jointly appointed, one of them alone can't make that decision. You bring the matter back to VCAT and VCAT will decide maybe there's a need for there to be a different guardian or administrator, or maybe the appointment needs to be changed in some other way. But the important thing is, if the appointment is joint and you can't reach agreement, the power can't be used and you need to bring it back to VCAT and we will assist in resolving the issue.
Thank you. The final question, Brendan, is can you give us a typical example of an application we would receive for a guardian or administrator?
Okay. Bear in mind this is just an example, and I'm going to give a person a name just because that will make it easier to describe. Let's imagine Leon is in his early 50s. He's involved in a serious motor vehicle accident and suffers physical injuries as well as a brain injury through the accident. The brain injury would be a disability within the meaning of the Guardianship and Administration Act. And if VCAT receives an application and a report that says Leon's brain injury is at such a level that it causes him to be unable to make his own decisions, then VCAT could then go on to explore whether there's a need for there to be a guardian and or an administrator. So we would process the application. We'd look at whether we have everything we need to conduct a hearing. We'd look to see if it were urgent. We'd look to see if Leon had ever signed an enduring power of attorney or appointed a medical treatment decision maker. We'd list the matter for a hearing, making sure that everyone who's got a legitimate interest in the matter knows when the hearing is on and is able to attend it. Let's imagine that at the hearing we hear that Leon is really determined that when he leaves rehab, he wants to return to his apartment where he was living before he had the accident. We also learn from the doctors and the carers at the rehab unit that they're really concerned about this. They feel that Leon either needs a whole lot of services coming into his apartment every day, or he might need residential care where the services are provided to him. If Leon maintains his wish to go home and others have a really different view about whether that's possible or not, then someone's going to need to be appointed with the authority to make a decision about where Leon lives and perhaps the services that he receives. So if we're satisfied that he's got a disability, that it causes him to lack decision-making capacity, and there's a need that can't be resolved in an informal way, then we would appoint a guardian. We'd assess whether a supportive guardian would be enough, but if not, we would appoint a guardian. Now, if the application also sought the appointment of an administrator, we'd again have to look and see whether Leon had ever executed an enduring power of attorney. If he hadn't, then it might be the case that he needs someone to manage his financial affairs. Someone might need to negotiate with his employer about payments that he might be entitled to. He might need to apply for a special sort of pension. Someone might need to pay his bills for him. There may also be legal matters that need to be sorted out for Leon. And so depending on the answer to those questions, Leon may well need to have an administrator with authority to make decisions about legal proceedings, as well as the ability to make decisions about his financial affairs. Thanks, Zoe.
Thanks for that, Brendan.
Can I just say before we close about that case study, I hope that you can see why it would be really important for Leon to be at the hearing so that we could hear from him firsthand about the things that are important and who he wanted to have assist him. Zoe, I'll hand back to you.
Thank you. That concludes this VCAT seminar for Law Week 2021, Becoming a Guardian or Administrator. We're very excited to be involved with this year's Law Week, an event that has long sought to make learning about the law accessible for all Victorians. Thank you all who attended and all who sent through questions. Becoming either role is quite an undertaking, so we hope we were able to simplify some of those processes for you, and we hope that you learnt something from this presentation. We're happy to answer any additional questions you may have, so if you have any, please feel free to email them through to communications@courts.vic.gov.au. Thank you.
Thank you.